Hi, I'm Kalpana Singhal, Editor-in-Chief, Health Technology, a community under CXO TV, Tech Plus Media. Welcome to the fireside chat on sharing data and ethical challenges, AI and legal risk. From clinical applications in areas such as imaging and diagnostics to workflow optimization in hospitals to use of health apps to assess an individual's symptoms. Many believe that artificial intelligence, that is AI, is going to revolutionize healthcare. With this growth comes many challenges, and it is crucial that AI is implemented in the healthcare system ethically and legally. There are important questions your organization needs to ask itself as you start the journey and as you move forward. This fireside chat will map the ethical and legal challenges posed by AI, directions for resolving them. We have invited very eminent guest who is a legal expert on commercial, regulatory, litigation, investment, white collar, and intellectual property matters. Please welcome Darren Punnen, leader, Pharma and Life Science Practice, Nishith Desai Associates, to this very interesting fireside chat. A very warm welcome to you, Darren.
Thanks, Kalpana. Thanks a lot for having me.
Yeah. Darren, where do we stand when it comes to safeguarding patients' rights and privacy in India vis-a-vis global laws?
Yeah, that's, it's a good opener because I think when it comes to the safety and security of healthcare data in India, especially when you compare that with where we stand globally, I'd say that India is playing catch up. If you look at the current legal framework today, we don't have a healthcare specific data privacy legislation, although we did try to implement something a few years ago in the form of what we refer to as DISHA, which is a Digital Information and Security in Healthcare Act. However, that never came to fruition. What the legislature is currently doing is that they are in the process of implementing a new general data privacy regulation, which we hope will incorporate some of the concepts that we saw when DISHA had come out. And have a healthcare specific regulation under a principal law, which overall governs data privacy in India today. When we look at where we stand currently, I'd say that the entire framework is geared towards protecting sensitive personal data, but not data overall. And we've seen that globally with the introduction of the GDPR in European Union, with the introduction many years ago of HIPAA, as well as some of the newer legislation such as the California Consumer Protection or the California Consumer Privacy Law, we have evolved to try and regulate and protect data as a whole. And fortunately, with some iterations of the current proposed bill on data privacy law in India, we've also moved to that level where we're not looking to only protect sensitive personal data, but data overall. So when it comes to health data, I believe that is an advantage because when it comes to health data, we're not looking only at specifics like biometrics or credentials, because a lot of information that is put out in terms of what a patient is able to provide to a healthcare provider, that in combination with personal information may still amount to something that could fall within the cracks if an overall data protection law is not put out. So I think we're moving in the right direction. But like I said, I think we're playing catch up when it comes to global data privacy law today.
Yeah. So how do Indian laws interpret on AI/ML implementation in healthcare, including imaging, diagnostics, and patient medical records?
Right. So Kalpana, I'd say that we don't specifically have an AI/ML legislation today, primarily because the main legislation that deals with data privacy was released somewhere in 2000, right? And at that time, we were not looking at AI and ML so closely. So therefore, the legislation was not aligned to take care of that kind of technology. However, it doesn't mean that AI or ML is completely unregulated. Obviously, because AI and ML are basically foundational in terms of it being built on data or raw data that comes from multiple different sources, the primary data itself is still something that is regulated. So even though we don't see specific legislation on the AI and ML front, we still have protection with the existing framework. And as I mentioned, once we move into the new data privacy law, we will definitely see some more specific legislation on this front. But that being said, there are many policies that have already been put out which directly deal with the AI and ML. For example, the Niti Aayog have already put out a couple of policy papers which deal with artificial intelligence, machine learning, not only in the general context, but also in a specific healthcare context as well. And they've been able to highlight some of the issues as well as some of the ethical concerns when it comes to the use of AI and ML in healthcare as well. So we have a good foundation for where policy can eventually develop into the law. And to that extent, I believe that the policymakers have already identified and looked into the right aspects that we have to look at today. I think the one place where we've already seen an implementation of some regulation with respect to AI and ML in healthcare is with the recently released telemedicine practice guidelines. And this was a guideline that came out somewhere in March of 2020, which basically talked about the use of AI and ML in providing healthcare. And it came out in a very guarded form. The reason being that today, when we look at AI and ML in India, there is still a long way to go before we're able to use AI or ML as a standalone option for diagnosis or treatment. So the telemedicine practice guidelines specifically called out that when it comes to the use of such technology, it should not be done as a standalone, but it should only be done as a aid or assistance to existing healthcare practitioners. So while it is okay for a registered medical practitioner to be using AI or ML as supplemental to their overall diagnosis, it cannot be used today as a standalone software.
Okay. So what exactly means when you say standalone software?
Yeah, good question. And also there is a regulatory framework to that as well. So when we talk about standalone software, it means that it's either not embedded into a particular hardware or it is capable of being able to provide the end output without any other intervention. And to give you an example, IBM's Watson is a very good system today that we have, which tries to predict the course of an oncology issue by screening many different inputs, for example, X-rays, CAT scans, CT scans of various patients who have had oncology issues in the past and have provide sort of a predictive diagnosis in terms of whether a patient coming in today has a risk of developing cancer or is in the early stages of developing cancer, even earlier than when a practitioner would be able to see that within a scan or any medical record. So that would constitute a standalone software. And fortunately, the way that we have seen the legislative framework develop is that standalone software already has in place a regulatory framework, and it's going to be regulated as a medical device within the larger scheme of the medical device regulatory framework. So if you are looking into developing software such as this, it is likely that you will be governed as a medical device for the purposes of healthcare treatment at least.
Yeah, absolutely. So introducing AI ML into healthcare opens up legal risk, especially once you start using patient-generated data or implementing the technology into your workflow and clinical decision-making processes, as you said. Then according to you, what are the legal and ethical challenges of AI in healthcare when we talk about informed consent to use, safety and transparency, algorithmic fairness and biases, and data privacy?
Yeah, thanks, Kalpana. So I think I'll break this down. So first of all, when it comes to the challenges overall, I think, first of all, we're in a good place to start, primarily because when we deal with AI or ML, we're largely dealing with anonymized or pseudo-anonymized data. So there itself, there is a level of protection provided in terms of patient privacy, primarily because we're dealing with anonymized data, right? So patient identifiers such as name and anything that could possibly identify the patient is generally removed before it is being used for the purposes of training AI software or for the purposes of training a machine learning program, right? However, that doesn't mean that at the time of collection, we can be relaxed, right? Because in order to be able to anonymize patient data, we need to collect patient data in the first place. So the challenges there currently is that when we look at anonymized data, it largely falls outside of the scope of current regulatory framework, both from a data privacy perspective and overall from a healthcare data privacy perspective as well. The only safeguard that we have today is when we collect that personal data or sensitive personal data, the fact that we are processing that into anonymized data is something that requires consent as of today. So luckily, the patients as well as any data owner is able to provide their consent before their data is used for the purposes of AI or machine learning technology. So to that extent, I think we do have that safeguard built in place. However, it is definitely something that needs to be looked into to the extent that anonymized data and how anonymized data is treated in today's context is something that we have not gotten into, but we will be getting into when the proposed law comes into place. For example, the standards that we use for the purposes of anonymization is very important, primarily because when we look at anonymizing data, we must use standards that make sure that it does not lead to a situation where the identity of a person can be reverse engineered from the data that's been submitted. So primarily when we look at that, there are certain ways in which we can make sure that the data can be irreversibly anonymized, which is the standard that we need to implement at a uniform level universally. So this is one. And again, I think the ethical concern, the concerns that we look at is primarily in terms of data bias. And this is something that is currently unavoidable, primarily because AI and machine learning, they learn from where? They learn from existing data. And unfortunately, from years of data bias that is already in the raw data, the issue is that it will automatically start percolating into the AI and machine learning. So there is some requirement to try and counteract the bias that comes with the existing data. For example, racial bias, ethnical bias, these kinds of bias needs to be counteracted by at least making sure that the data collected is as diverse as possible, so that we can try and limit the amount of bias that moves into the AI and machine learning platforms and technology. So I think that becomes a very important ethical concern. Another thing that we have to look into is also transparency and overall protection of the data. And these two come combined because one, if there is, and at this point, I would say that again, data breaches are not completely avoidable because nobody can protect from an absolute secure system that can lead to no data breach. However, the way in which an entity will deal with that data breach is very important. And that's where transparency comes into the picture. Notifying your data principals when there is a data breach, what exactly you do after a data breach takes place, and how best you can protect the overall outcome of a data breach is important. And there needs to be some sort of a guideline which deals with how data breaches need to be reported and dealt with. So that becomes important as well. An example that floats around today is by attaching the existing data onto or pairing it with a blockchain system so that it is transparently and uniformly distributed across the ledger, so that we're able to be more aware of how the data is being used. And whenever there is a breach, you're able to see it, even if a company is not able to report it, right? So there are different ways in which we can tackle these problems, but today we do see that there are concerns that need to be addressed in the overall system for AI and ML.
So according to you, blockchain is something which can really help in actually making the data to be used ethically and responsibly. So what do you think? What is holding the government back or even the private bodies back in using blockchain? Is it very expensive or what is the scenario?
So that's a great question, and I think I'll give you the example of a small European country, Estonia. And in Estonia, not only is healthcare records, but all government issued records are part of a blockchain system. And that's become such an important part of the overall governance framework, because whenever we look at healthcare data, we don't look at receiving healthcare services from one provider, especially in a country like India, where public health is not as large as the private healthcare system, right? So we're looking at multiple different providers who have access to your data in multiple different forms. So if you're able to centralize that data, you're also able to provide a uniform method of collection, which is again important in terms of the health records and how to make sure that they are interoperable today. So if and again, to come back to the example of Estonia, every time your data moves from one entity to another or is accessed by one entity or another, the principal of that data is able to know and even provide consent where required, so that all of this is happening on a transparent system. Now, the challenge in implementing this, I think, Kalpana, you've pointed that out correctly. It is going to take time, and it may be an expensive affair to be able to first, especially in India, where the way in which we have collected electronic health records are currently in all different kinds of formats. There are no uniform formats that we have used right now. So to get that data into a uniform format, to be able to feed it onto a system like a blockchain system is going to take time. And it also needs a collective effort by everybody in the healthcare ecosystem, which again, like I mentioned, there are so many private players that if you need everybody's sign off to implement something that is universal, it's something that will take time.
Yeah, absolutely. A fair point. I would say that the data is in an unstructured form in our country, basically. So first it has to be in a structured form, and there should be standardization, and then probably we can think of.
Yeah.
So what is a model you would suggest for ownership and exchange of health data while utilized by the AI algorithms?
Sure. So I think the current scheme of healthcare data ownership should continue even when we look at AI or machine learning. The reason being that the overall standard that is universally applied, not just in India, but globally, is that when it comes to patient data, the patient data is always owned by the patient themselves. And it is always held in trust by anybody who collects it, right? And that ownership should never change hands. It continues to remain with the patient, primarily because if tomorrow the patient wants to withdraw their consent, if they want to modify that data, they shouldn't need any sort of permission from anybody to be able to do so. And in fact, any person who holds that data in trust should be able to facilitate for that to happen at any given point of time. So that's on the raw input side. However, when it comes to what output you get from AI or machine learning, primarily what they build are data sets. They build algorithms, they build databases of a lot of information being put together. So from an intellectual property and overall ownership point of view, there is a principle called the sweat of the brow, which basically means that if you have put in effort to create a data set or a database, that ownership should lie with the person who has done so. So, and to that extent, I don't see an issue with being able to provide ownership of the algorithm or the data set to an AI or machine learning developer, primarily because when we reach that stage, we are typically dealing with anonymized data, and that data, at least in the form and manner in which they have put it out, does require some amount of protection so that there is incentive to develop these things further.
So AI in healthcare system would entail sharing and analyzing a lot of patient and clinical data and produce new outcomes. So this not only raises concerns around privacy, but also security issues. And what are your thoughts about dealing with these challenges?
Sure. So on the security side, as well as maintaining privacy, today, again, fortunately, we're not looking at only one law which deals with data protection and privacy in the healthcare context. And so there are different entities involved when it deals with how exactly data needs to be handled, right? So of course, we have today the overall data protection framework that applies to all data and not specifically healthcare data. But at the same time, at the practitioner level, the primary person who usually is responsible for collecting such kind of data, there are already confidentiality and protection measures built in right within their own licensure framework itself. So today, if you're a healthcare practitioner, there is an obligation on you as a healthcare practitioner to maintain the confidentiality and privacy of your patient data. Not only that, the law goes to the extent, and I would say that this is a very forward-looking law for the time that it did come out, because we're looking at a 2002 legislation which recommended back then itself that healthcare practitioners, to the extent possible, should digitize their health records. Even though a standard was not put out, at least the concept of making sure that all of it was digitized was put back in 2002 itself. And the other entity that then deals with this kind of data is the healthcare institution. For example, it could be a diagnostics facility, it could be a healthcare a hospital, for example, and they also have their own sets of regulatory framework, primarily dealing with how, again, all tied to the licenses to these kind of facilities. And to that extent, you do see that there are certain requirements to maintain and protect that healthcare data as well. On top of all of this, we also have the Ayushman Bharat scheme, which is rolling out, or in fact, it's rolled out to a large extent. And luckily, even there, combining the overall Digital India mission that we're looking at and the overall push for digitization in the country, the Ayushman Bharat scheme also requires a certain amount of data protection, data uniformization, in order to be able to onboard onto that system itself. So you find that many healthcare systems or healthcare institutions that want to be able to participate in the scheme, and there are a large number of them, actually do have to comply with these requirements before they're able to get onboarded. So one issue, and I think what becomes clear, is that there are different levels of framework for different entities. And yes, of course, we have an umbrella framework overall. I think what's needed is something that basically puts everything together so that the entire ecosystem is governed by a uniform standard for protection and privacy of healthcare data.
Yeah, absolutely with you. But don't you think, Darren, that though the fancy names that we have around data protection is we are talking since 2002 kind of, and then we also have Ayushman Bharat, but most of these schemes, it's hard to actually for the healthcare providers to actually take an advantage of, because of the complex framework and these kind of compliances. So how technology can actually help out in making things simpler, so that actually whatever government is taking as an initiative, the healthcare providers and ultimately the patients can also get benefited out of it.
Yeah, no, I completely agree, and I echo your thoughts. The way in which today compliances need to be undertaken, one is that it is very scattered, making it difficult for anybody in the system to be able to get onboarded, to be able to provide these healthcare services, etc. So, like I mentioned, I think the first task is to be able to provide single window clearances, right? And basically that means that you combine what is already out there so that people don't have to duplicate their efforts in order to be compliant. And that challenge is something that has already been identified by the government. And in many instances, they have taken care of that. I would say not specifically in the healthcare framework yet, but I believe it's on the radar to also provide for that kind of flexibility and convenience in the healthcare compliance ecosystem. We have definitely taken steps to that extent. For example, the digital health footprint that's come out recently, the data health mission that's also come out recently. All of these, I would say that we are at the foundational step towards getting to where we want to be, which is basically making everything uniform, bringing everything universal. It's going to be something that's of a challenge considering how scattered the overall ecosystem is. So first of all, there is no one law today which governs all healthcare stakeholders in one umbrella. So in order to be able to implement something at that universal level, you first need a principal legislation to do that. And definitely the government has identified that issue, because just recently we were also participating in providing feedback to a digital health mission objective that the government was trying to achieve, where one of the first questions that they asked is, how do we implement this uniformly, right? Yeah. And I think it's great that the government is asking us also, how do we do this? Because they've already seen that today we have like a mishmash of so many different kinds of legislations and laws, and they're open to feedback to try and figure out how we can streamline that entire process. Yeah. So it's a great step. I would think that it would take probably another 5 years or so before we see something, but I'm very happy that we are already starting the process.
Yeah, thankfully you have started with it. Yes. Yeah, that thought is there. Because in tier 2 and 3, so it is kind of impossible, because the healthcare providers think whether we focus on our core business or we should have people to actually look into the frameworks and these complex things.
Correct. No, in fact, I would say that at the tier 2, tier 3 level, we are still at the first hurdle of digitization. Yeah. We still deal with physical records. And the thing is, with AI and machine learning, it's so important to have data that can be analyzed. And in order for that to happen, you need it to be in a particular format. So we are 2 steps behind when it comes to tier 2 and tier 3, primarily because we're still dealing with physical records. If anything, these records may be scanned, and whether that scan can be actually analyzed by a machine is another question altogether.
Yeah. Still, in tier 2, 3, even in metros, doctors are still writing down the prescriptions, and then in metros, at least those prescriptions are being scanned and kept in records and getting digitized. But in tier 2, 3, I don't think, even that is happening.
That's right. Yeah.
So long way to go. Yeah. Yeah. Okay, so what are the safeguards healthcare laws have to curb private exploitation by individual firms?
Yeah, I think there are 2 things here, right? So one is on the input side and the other is on the output side. On the input, when I talk about input, I mean when we collect data for the purposes of processing it for machine learning or AI. And primarily, I believe one is, of course, consent, right? Today, there are unfortunately ways in which you can avoid having to obtain consent when it comes to anonymized data, or when it comes to data that has been processed for the purpose of anonymization and then transferred to another entity that will deal with it. So instead of trying to figure out how best we can remove consent from the entire picture, I'd rather have that as an integral part of the process of collection and processing of the data, primarily because, like I said, if the patient is the absolute owner of their data, I believe they should have the power to be able to decide whether their data should be used for particular aspects or not, regardless of whether a framework says that I need to obtain consent or don't need to obtain consent. So this is an interesting concept that has been developed globally and is also becoming something that we are seeing in the Indian framework, which is called privacy by design. And that basically means that when you prepare or develop a particular product, privacy should be at the forefront of these things. And as you develop that product, the design should implement certain privacy standards as well as data protection standards as well. So if right at the start, we look at how exactly we can ensure the best data protection and privacy from a healthcare data perspective, I think at the input side, which is again one of the most important parts, that would be very, very good from a safeguarding perspective, because tomorrow you don't know what kind of liability you will meet if you don't follow the full extent of the law or follow the full extent of the spirit of the law itself, right? So I would say that, of course, consent becomes one of the most important and integral portions. The other is then when it comes to processing, and here the anonymization that takes place needs to be of the highest standard. And when I say highest standard, I mean that efforts should be put in to make sure that they are irreversibly anonymized, so that even in the event of a data breach and there is a leak of information which may be anonymized, there is no scope for it being de-anonymized and being able to be identifiable to a particular person at all, right? So this is on the input side and the processing side. When we look at output, again, it really must be focused on to try and get the entire bias that we're seeing today removed. And to that extent, I think the only thing that entities today can implement is to try and ensure that whatever data is being collected today is from as diverse a population, as diverse overall that you can collect. Because if you want to be able to implement an unbiased and fair system that's able to have better patient outcome, the only way you can do that is to try and make sure that data is collected at as diverse as possible. And to that extent, until we are sure that data bias is something that has been taken care of at the foundational level, we must also ensure that the current existing framework continues, which is basically that AI and ML should not be used as a standalone to the extent that we don't believe that it has the capability of being able to diagnose or treat independently so far. But right now, it is and will always be a very great tool to supplement existing healthcare framework as well as existing healthcare services. So to that extent, I think the safeguard would be that we continue to be mindful of the fact that before we reach the ultimate stage of independent healthcare services through AI or machine learning, we remove some of these issues in the technology and then only get to that final stage.
Yeah, absolutely. So what are your suggestions and best practices for healthcare organizations to keep legal challenges at bay while leveraging on the benefits of AI/ML?
Yeah, so I think if I had to leave entities with a single point, it would be compliance, right? Compliance right from development stage. And I think really absorbing the fact that privacy by design is a concept that needs to be implemented, not only from an overall push to have AI and ML in the healthcare services at the forefront, but also from a company's own liability and risk mitigation perspective. I think if right from the boardroom to the software developers table, wherever you are dealing with this kind of technology, I believe privacy and protection should always go hand in hand. And the best guardrail or measure that we can use at that stage is, of course, the existing law. And if we are compliant with the existing framework today, I think a lot of challenges that we're looking at would automatically fall away for entities dealing with such a space. Of course, I think one eye should also be kept on the horizon, primarily because this is a very fast developing space. So being in tune with some of the policy papers, some of the consultations that are going on, and actively participating in these kind of activities primarily because today the government is very open to receiving this kind of feedback. If there is more participation, we will be seeing a much better developed law because the stakeholders themselves have identified and participated in that process. So I think, like I mentioned, compliance is key, and one eye on the horizon would be optimal to get to where we would like in terms of how AI and ML are implemented.
Absolutely. So thank you for answering that last question, and thanks a lot, Darren, for elaborating on legal and ethical challenges healthcare organizations face with AI implementation and possible remedies to avoid any legal challenges. I'm sure your insights will be of much importance to our audience.
And thanks a lot, Kalpana. Thanks for having me.
Thank you, everyone, for joining, and stay tuned for our upcoming sessions.